Welcome. I'm Dinah Pokempner, and I'm going to talk to you about surveillance and human rights today. I come to this topic as the General Counsel of Human Rights Watch. We do a lot of work on freedom of expression as well as privacy, and I also teach at Columbia International Human Rights Law. So what's state surveillance? I'm going to define it as non-consensual, surreptitious data collection, analysis, use, and data retention by state agencies or at the behest of government authorities. State surveillance can be deployed for a lot of very valid reasons. It can be used for solving or even deterring crime, for national security purposes. The word tends to evoke rather cinematic images for many of us. We think about maybe the police on a stakeout. We think about spies bugging someone's room or tapping someone's phone. Maybe someone being followed through dark alleys. But this is a very 20th century way of thinking about it. When these kinds of images that we pull from the movies, these usually involve the surveillance of a particular target for a particular purpose in a particular place. Surveillance today evokes very different kinds of association. If you've been reading the newspapers at all, you'll probably think of surveillance as the government monitoring our every click at every moment, or capturing our cell phone communications and all the records about those cell phone communications. Maybe you'll think of government hacking into our computers and turning them into devices that track us. How did we get to this sort of new and radically different and rather dystopian idea of surveillance, where privacy seems elusive or even meaningless? In large part, we have someone named Edward Snowden to thank. In 2013, Edward Snowden was contracted as a systems analyst to the National Security Agency, and he had tremendous access to its operations and its various programs in that role. And he began to be very disturbed by what he saw as huge government overreach that was unconstitutional. He was dismayed by the breadth of the information that was being collected, the weak legal authorities and oversight, and when he tried to complain to superiors, they dismissed his concerns or told him it really wasn't his problem. He also observed the severe retaliation that other NSA whistleblowers had experienced and decided that his only recourse would be to take his concerns to international journalists who were experienced in national security matters. And with that, he contacted Glenn Greenwald and Laura Poitras, and he released a huge volume of internal NSA documents that opened all of our eyes to the kinds of surveillance that the US government was engaged in. The first program that Snowden and the news organizations working with him revealed was something called Prism, which was a program under Section 702 of the Foreign Intelligence Surveillance Act that allowed the government to access communications being hosted by major internet companies such as Google and Yahoo, and to collect and store that content. A different program was a program that systematically collected vast amounts of metadata about internet and digital communications under Section 215 of the Patriot Act. Now, what's metadata? Metadata is data about a communication. It's the who did I call, when did it happen, where was I at the time stuff, not the actual content of what you said. But it can be extraordinarily revealing about someone. Think about a a series of calls. First, you're talking to your doctor at the oncology section. Then you call your mother. Then you call your lawyer. Then you call a hospice company. Boy, we'd know all about what was going on in that case. So metadata can tell a huge amount, sometimes even more than the content of the communications. And this was being collected in vast amounts by the government under orders from a secret court that enabled very, very liberal interpretation of the law that essentially allowed for mass collection. Other programs that eventually were revealed were equally alarming in scope. It turned out that the government was tapping underseas cables through which many foreign communications were being transmitted. The government was swapping information with its foreign intelligence partners and allies, the Five Eyes. It turned out that the government had engaged in efforts to weaken encryption standards. The government and its partners were engaged in hacking on a wide scale. All of these revelations began to make people wonder how secure their communications really were. Now, the Obama administration at the time was trying to limit the damage and assure people that the government wasn't really interested in reading their email, but it was collecting it on a vast scale. And it became increasingly unclear what communications were being collected by the government and with whom they were being shared. Now, the government claimed that what it was doing was perfectly legal, but it was clear that the interpretations of the law that the government relied on and that the government persuaded the secret court that was empowered to hear its requests under law were very different understandings of the law than what the drafters of the law had originally thought. This was part of what also became evident through Snowden's revelations, that there was a vast failure of democratic oversight of the surveillance process. Processes that were cloaked in secrecy were not well understood even by the congressional representatives that were specifically authorized to hear about them, learn about them, and monitor them. There was also a huge program of surveillance being conducted under an executive order, and Congress is still in the dark, as well as the public, about the extent, the means, and the scope of that particular surveillance program conducted under what's called Executive Order 12333. The total effect of these revelations was to make many observers feel that the U.S. government was creating something that resembled the philosopher Jeremy Bentham's idea of a Panopticon. The Panopticon was Bentham's proposal for a new prison design where one watchman could observe many prisoners all at the same time, never letting the prisoners know exactly when they might be under scrutiny. Now, the government programs were a bit different than Bentham's idea of a panopticon because Bentham's idea depended on prisoners understanding that they were under observation. The government believed that the efficacy of its mass surveillance depended in large part on its secrecy. Those who were under surveillance shouldn't know that they were under surveillance, lest they take means to evade surveillance. And this is one of the reasons why the government reacted so furiously to Snowden's revelations. Snowden was indicted under the Espionage Act. He lives in exile in Russia today because no other country would give him refuge as a direct result of U.S. pressure. It's been 3 years since Snowden's revelations started, and the global impact is still being felt. In the immediate aftermath of the revelations, there were serious foreign policy repercussions. The leaders of Brazil and Germany, both U.S. allies, had been under NSA surveillance. They reacted strongly and sponsored 2 different UN General Assembly resolutions that condemned the United States surveillance programs obliquely, and that impelled the creation of a report by the United Nations High Commissioner for Human Rights on the right to privacy in the digital age. This report really set forward the human rights standards on privacy and was, in effect, a stinging rebuke to the U.S. and other governments that had conducted similar programs. There were also very serious consequences for internet companies, particularly those global titans of the business that are headquartered in the United States. These companies stood to lose billions and billions of dollars as a direct result of lack of consumer trust. But they also came under quite harsh scrutiny abroad in foreign courts and foreign legislatures for their role, witting or unwitting, in assisting the U.S. government in these programs. Some of the results were much tighter data protection laws, requirements that these companies keep their data in the foreign country so that it would be accessible to the foreign government as well, efforts to compel the companies to drop content or release content through various legal doctrines. As a result, some of these companies have tried to be more transparent in terms of what requests the U.S. government makes of them, or any government for that matter. And in some cases, they have succeeded in doing so. In other cases, they've been blocked by the government, which has insisted on not releasing this information and not permitting companies to do so either. But secrecy and lack of transparency, of course, are not the only types of harm or concern that these surveillance programs generated. There were serious implications for many human rights. Privacy, of course, but also freedom of expression, freedom of association, and lots of other rights, depending on the situation. The harm to human rights has been documented in a variety of ways. There is a chilling effect on free expression that can be seen even in how people search Google for controversial terms. There are huge concerns among groups of people whose communications have good reason to be confidential. People such as journalists who don't want to reveal their sources, or lawyers who must keep their communications with their clients private and confidential. Human rights researchers who often go into very dangerous situations and talk to very vulnerable people about criminal matters. There are all kinds of people who have had to find other means of protecting their communications, or have had to simply communicate less as a result of their awareness of this constant and massive surveillance that national intelligence agencies are engaging in. So what happened to the old rules that used to govern old-fashioned surveillance? Things like court orders or warrants that would only issue if there was probable cause to think that surveillance would somehow yield information that was relevant, for example, to the investigation of a crime. This huge program of intelligence surveillance, which was being shared with other governments, shared with law enforcement, threatened to overwhelm the old legal constraints on government snooping. The short answer to where we are legally is that while rules for national jurisdictions have been changing and new legislation has been formed in some ways to protect the surveillance practices of states, the old human rights rules haven't changed. International human rights law protects these rights in several ways. For one thing, Intrusions on rights such as freedom of expression, privacy, association have to be provided by law. That's one reason that many countries moved after the Snowden revelations and the uproar they caused to suddenly put their surveillance practices into law. They may have been conducting surveillance, but it may not have been entirely legally authorized. Another key limitation is that intrusions on rights have to be justified by some compelling state interest. Now, national security is certainly a compelling state interest, but it doesn't mean any possible interest of the state. You generally think of national security as protecting the state against a threat to its territory or security. But not every single potential national interest can fit into that definition. So simply surveillance for the sake of knowing what every other country and every other person in the world is thinking would be hard to justify as national security. Another limitation that is typical for all these rights is that whatever restriction, assuming it's embodied in law and for an important state purpose, it must be necessary in a democracy, and it has to be proportionate to the justification. So mass surveillance by its very nature seems to be a disproportionate measure. It's hard to imagine many situations where getting everybody's communication, everyone's click and thought, really is either necessary in a democratic type of society or proportionate to any threat, even the threat of terrorism. These basic principles were reiterated by civil society groups in a document called the Necessary and Proportionate Principles, or the 13 Principles, and they were echoed in great measure by both the United Nations High Commissioner for Human Rights, the various special mechanisms such as the Special Rapporteur for Freedom of Expression, and they were also applauded in the Human Rights Council. However, this hasn't stopped or limited the trend of legislation in national jurisdictions, and there are a number of reasons for this. Unfortunately, the Snowden revelations came about the same time as a new wave of concern about global terrorism hit. The conflict in Syria and also in other parts of the Mideast and Africa has been exploding, causing a massive outflow of refugees, renewed terrorist incidents around the world. And so states are very, very concerned about protecting security. Many states were alarmed at the degree to which they had become dependent on U.S. intelligence and wished to develop their own intelligence capability and make it stronger. They began to emulate U.S. law, U.S. approaches, and to legislate in ways that granted them exceptional powers of digital surveillance. At the same time, it's been very, very difficult for ordinary people to obtain information about surveillance practices and the degree to which their own government or their government's allies may be monitoring their communications. This has been exacerbated by the fact that challenging national security practices, such as state surveillance, is very, very difficult in courts. Governments often have a wide latitude to either claim that the individual has no right to that information, that they can't answer such questions, or that the individual simply doesn't have standing to sue because the government won't confirm whether or not they've been a target of surveillance. That, in essence, would confirm whether surveillance was happening and allow people to evade it. These problems have led many activists to resort to litigation, simply to get information as well as to challenge laws. Human Rights Watch, for example, brought a case against the Drug Enforcement Agency, which had been conducting its own mass surveillance program, a program that essentially was the prototype for NSA surveillance. We did it even though the government claimed it had discontinued the program and deleted the data because we wanted to be sure that this was actually a program that was dead and gone and the data gone too. We did finally dismiss the case when the government affirmed that, in fact, it had deleted all the data it had collected from all U.S. databases. Similar kinds of actions are going on in the United Kingdom. There are also actions that facially challenge the power of the government to engage in the kind of surveillance and the kinds of interpretations of the law it has. These are very difficult to conduct in the United States because in the United States, to have standing, you have to show you've actually been harmed by some government practice. And of course, the government isn't going to confirm whether or not your suspicion that you've been surveilled is true. We're having greater success in European jurisdictions where the standing requirements are not as rigid. And we do expect that some important decisions may be coming shortly, such as the Big Brother Watch challenge, where many human rights groups have intervened before the European Court of Human Rights. So where does this put us in terms of our own privacy and protecting our own privacy? Many people are increasingly interested in end-to-end encrypted services, and companies are starting to provide these programs not just to the digerati or those who have advanced knowledge of various types of computer programs, but to ordinary people using mass global platforms like WhatsApp or iPhones or other kinds of very popular and ubiquitous programs. The popularity of these encrypted platforms is causing a lot of concern among law enforcement officials who often talk in very ominous terms about going dark. And what they mean by going dark is that they are entering a new era where the government will not be able to eavesdrop on every conversation it might otherwise have found. Now, for anyone who has as much white hair as I do, you'll remember a time when where there was absolutely no question when the government couldn't listen to every single conversation. We didn't used to have an expectation that government would be able to access every single piece of mail, every single telephone call, every street conversation. Of course, these days, we're more accustomed to having the world at our fingertips and all information accessible through a simple search, and apparently so is law enforcement. This issue of the government accessing encrypted communications, though, is a very hot issue, and it's going to stay with us, I'm afraid, for many years. You will probably remember the case that the Department of Justice brought against Apple. It wanted Apple to write new code that would enable it to break into the iPhone that the San Bernardino shooter used. The government chose this particular case, I'm sure carefully, because everyone was horrified at this terrible crime, and no one wanted it to repeat. And yet, the government's case brought a backlash. Not only a backlash from Apple, which objected to having to help the government in this extremely proactive way, essentially to create something new that would break the security of its product, but also from many civil libertarians and from many other companies. And this is because there is a problem with trying to circumvent encryption. When you break strong encryption, it weakens security, and it weakens it not just so the government can get in, but so anyone can get in. In other words, so hackers, criminals, pranksters, all kinds of people you might not want to get into your data would have a more vulnerable device or platform to deal with. And this is a tremendous problem for us. And it's not just a problem for people who don't like the idea of all their interactions with a dating service being broken into. It's also a problem for anyone who relies on security of communication for banking, health information, insurance information, employment records, all kinds of things that our society could not really function if they were broken into or easily accessible to criminals, hackers, or simply precocious adolescents looking for a good thing to open. This should give us pause about government efforts to completely render the public's communications transparent while still relying on national security rationales to, in some cases, divulge the least amount of information they can about the very programs they're using for surveillance. This kind of problem, this kind of struggle between state interests and human rights and security is likely to go on for quite a while yet.